Watching News at Prime, let's pick up on this discussion now. The National Prosecuting Authority is studying the findings of the Life Esidimeni inquest into the deaths of over 140 mental health patients. They were transferred from Life Esidimeni facilities to NGOs that were unregistered and ill-equipped to carry out this particular exercise, and this was described as a cost-cutting measure by the Gauteng Health Department. Now, the judge found that former mental health director, Dr. Makgabo Manamela, and the former MEC of Health in Gauteng, Qedani Mahlangu, were negligent, leading to some of the deaths. Let's discuss the NPA's next move. Advocate Mthunzi Mhaga is with the NPA. Advocate, good evening to you, and thank you very much for making time for us here.
Good evening, Qedani, and to your viewers. Thanks for having us.
Thank you, sir, for coming through. So let's begin with what your statement has said this afternoon, and I quote now: the NPA is committed to ensuring accountability for any crime committed in relation to this national tragedy. What will this mean in practice?
What it means, Toli, is that we will have to now adopt a strategy that is led by a prioritization of the matter, expedite any additional investigative process that needs to be undertaken by law enforcement, that is the South African Police Service. Remember that whatever we do, we rely on investigation and evidential material that would have been presented by law enforcement. That will be done in conjunction with assessing thoroughly the judgment that was delivered by Judge Tufo and the findings adversely that were made against the two individuals, to make an assessment and a determination if there's relevant and admissible evidence that can sustain charges that can be mounted or preferred against them. That process will be expedited because of the importance of the matter, because of the tragedy that befell this country, where over 143 people died, or patients died that were in custody of the state. Now, what is important for us as the country to note is that an inquest does not necessarily equate to a trial-ready case. What it means in simple terms is that when you get inquest findings, you don't just take that docket straight to court and prosecute people. You have to make an assessment of whether I have relevant and admissible evidence, credible witnesses that can withstand the rigor of a cross-examination by the defense counsel who would have been hired to defend those that would have decided to charge in a criminal trial. We will channel all our resources to ensure that there is a successful prosecution when a decision has been taken. Remember, I'm saying when a decision has been taken. But what is important is an assessment of the judgment, is an evaluation of available evidence. And if there is a need or a necessity for additional investigation to be conducted, that process will be expedited when we work closely with law enforcement.
And that's why in your statement you say that the Gauteng Director of Public Prosecutions is studying this judgment with a view to determining whether the NPA will institute criminal charges. Does this mean then, I know you've said that whatever has come out of the inquest is not trial ready, but does it mean though that the information that this inquest relied on to come to the determination that the two individuals mentioned were negligent, is all of that information of no consequence to the NPA or for the NPA?
It is of great consequence, Oli. I am saying, in addition to evaluating that which is contained in the police docket, the findings and the judgment in the inquest will be considered. That's why he is going to adopt a holistic approach, robustly so, to ensure that he leaves no stone unturned. No piece of evidence will be ignored. All this information will be collated and put before him and his team and experienced prosecutors will be assigned to the case to ensure that the decision that is taken stands the test of time.
And the two individuals, the judge was specific that it's about 9, if not 10
patients.
10 patients
Yes.
who died were directly linked to the negligent behavior of the two individuals. Will that be the scope of the NPA's investigations?
It's going to be broad in the sense that when you analyze evidence, you can adopt a dogmatic approach that says, because the judge has said, let me look at the 2 and the 10 patients, and if additional investigations brings about pointers, you ignore those.
Yeah. Finally, on this matter, the families want closure, and I would imagine in the shortest possible time. So, if the NPA is going to conduct further investigations or outstanding investigations, how long will that go on for?
Remember, there are about 10 patients for which an adverse finding has been made.
Yeah.
There are additional 133 against whom no finding has been made in respect of the 2 individuals. Now, this clearly tells you that this is a complex matter. But like we say in the statement, we're going to implore on the law enforcement to expedite whatever additional investigation may be necessary, depending on what comes out of the assessment of the judgment and the inquest by the Director of Public Prosecutions. So it's difficult to commit to time frames, but we've undertaken, the National Director has made it clear to the DPP Pretoria, Advocate Mthunzi Mhaga, to say, make sure that we prioritize this matter because of its importance, because of its implications, because of the impact that it has negatively in the whole country.
And your work, therefore, will involve the police as well? Because
remember, we don't have an investigative mandate as the NPA except for the Investigative Directorate Against Corruption. But we, as the NPA, were only the prosecutorial component in the criminal justice system. We rely on law enforcement, that is South African Police Service, to conduct investigation and bring evidential material that is both relevant and admissible, which would then help sustain any charge in the event that a decision is taken to charge.
All right. I'd like to move on to a different matter.
Okay.
The VBS Mutual Bank, which is now non-existent. The former chairman of that bank, he's the former chairman of the board, Chief Mthunzi, pleading guilty to 33 counts of corruption and other related crimes. I'd like to find out from you, what is the nature of his cooperation with the prosecuting authority? Because the view here is that the sentence is relatively lenient.
It's not lenient at all, because remember, he has been sentenced to 495 years, but they've been ordered to run concurrently, which effectively is 15 years. And a direct term of imprisonment is, in effect, not a lenient sentence at all, because it's not a non-custodial sentence, it's a custodial sentence. And remember, this was a part of a negotiated settlement in the form of a plea and sentence agreement in terms of Section 105A of the Criminal Procedure Act. He has cooperated fully with law enforcement and prosecuting authority. That's as far as I can take in terms of the terms of that agreement.
I'm going to have to push you, though.
Other issues in terms of his role, unfortunately, for obvious reasons of not wanting to compromise the pending prosecution against the others, I will not get into that. I will not indulge you on that. Unfortunately, I'm not at liberty to do it. Safe to say that he has cooperated fully with both law enforcement and the prosecution of the team.
I note what you've said, but I'm going to perhaps
try your luck.
Try my luck.
Okay.
You say he's cooperated with law enforcement. Does that mean Mr. Mthunzi has turned state witness?
I am not at liberty at this stage to comment on that, but to say he has cooperated fully with law enforcement and the prosecution team.
What's also critical about this case, Mr. Mhaga, is the alleged involvement of political figures who are alleged to have used their influence in order to pressure municipalities to come to these deals with that defunct bank now. Mr. Mthunzi's cooperation, what can you tell us about his cooperation in relation to the political actors, or should we say alleged political actors?
Clearly, you must remember that we have additional accused persons that are coming to court on the 22nd of July for a pre-trial conference so that they can sort out whatever outstanding issues, preliminary issues, before a trial date is set, before the trial commences. All these issues that you want me to indulge you on will be best ventilated during trial when it proceeds. At this stage, all I can say is in respect of the 105 agreement between the state and Mr. Mthunzi. That's where, as far as I can take the matter.
15 years in jail for Mr. Mthunzi. When does he become eligible for parole? Or does this mean that this is 15 effective years behind bars?
When I was still at correctional services, if my memory serves me well, and my understanding is that he has to serve 1/3 of the sentence, then he'll be eligible for parole. If he behaves and undertakes or undergoes all the rehabilitation programs at correctional services, then he will qualify for parole.
Which is why the question about the leniency of the sentence
Once
stands.
again, a direct term of imprisonment, that being 15 years, not a custodial sentence, not correctional supervision, will remain a harsh sentence in our eyes.
Thank you very much for your time.